Alright. Good morning, this is Roger Guy of Chapter7Attorneys.com. I wanted this morning to do a short informational video about the bankruptcy process itself and what you can expect. Nowadays, the bankruptcy cases are filed electronically, which is actually very good because in the past, the bankruptcy lawyer's office had to make 5 or 6 copies of the petition and actually manually stamp it, have it delivered to the court for stamping. Nowadays, it's much better. The cases are filed electronically. And the benefit of that actually is this, that once the case is filed electronically, the automatic stay comes into play. And for those of you who don't know what the automatic stay is, it is really a injunction. It's a bankruptcy injunction. And what it does, it's under pursuant to 11 U.S.C. 362A, and that's formally known, that's the United States Code. It's formally known as the automatic stay. But basically, it's going to stop any collection activity against you. So for example, if you have a garnishment, that is going to be wiped out once we file the Chapter 7 case. If you have a lawsuit, filing the bankruptcy is going to stop that. Okay? If your house is being foreclosed, that is also going to stop. All of that activity is just going to stop by virtue of the bankruptcy filing itself. The other thing that happens is that there's an estate that is created at the time that you file the case. So again, none of the creditors can take any action against you. Once the automatic stay comes into place, then you're protected at that point forward. Now, of course, it's not that minute as far as when the creditors are notified. One of the reasons that you're paying the court cost, if it's a Chapter 7 bankruptcy case, you're going to pay $299 to the court clerk. And if it's a Chapter 13 case, you're going to pay the court filing fee of $274. What happens is this: once that case is filed, and again it's instantaneous, like where you are protected at that moment, then the court clerk sends out, and it's not your attorneys who do this. I get a lot of calls on, when are you going to notify my creditors that I filed? That's not really the function or the role of the attorneys. One of the reasons that you're paying the court clerk the filing fee is that they will mail out a notice of the fact that you have filed for bankruptcy protection. And so a lot of times the creditors, once they receive that notice, of course they follow and they comply with the law and they stop all of the collection activity. It is extremely rare that we get a creditor who, after receiving the notice of the automatic stay in the filing of the bankruptcy case, it's extremely rare for them to try to continue to take collection activity against you. Now, if they do that, you have a claim against that creditor. And that's a whole different topic matter. After that happens, then what happens? Well, the third step in the process is really what's known as a trustee hearing or a creditor hearing. It's also called a meeting of creditors hearing, and that's probably the more appropriate term, the meeting of creditors hearing. And that hearing takes place typically approximately 30 days after we file the bankruptcy case. So we file it July 1, approximately your bankruptcy hearing is going to occur within, by August 1, for example. At the hearing, what can you expect? Well, number one, the creditors can show up. Oftentimes they don't show up, particularly unsecured creditors. Let's say you have a hospital bill or a credit card debt. That type of situation, most of the time those creditors don't show up. However, if you have a mortgage or a vehicle that you're paying on or furniture that you're paying on, the creditor, a lot of times they will attend the hearing and they want to know whether you're intending to keep that property and pay for that property or whether you wish to just surrender the property back to the creditor. That is the third step of the process. Now, let's talk about the fourth step of the process. And I've broken these down a little bit because in a Chapter 13 case, after the hearing, you have also the case in a Chapter 13 bankruptcy case. The court has to actually approve your repayment bankruptcy plan. Remember, in a Chapter 7 bankruptcy case, there is no repayment plan. It is a complete fresh start, and you are absolutely trying to wipe out your debts. However, Chapter 13, that's completely different, and you may have to file a Chapter 13 for legal reasons. But in a Chapter 13 case, your hearing for the approval of your case is held approximately 60 days after your case has been filed. A lot of times, and it's very common, the Chapter 13 trustee's office will file objections to your case, okay? And that does not mean that the case is going to fail. It doesn't mean that you've wasted all of your time, money, and effort, and that you are not going to be protected. What it means is that maybe something has to be fixed in the Chapter 13 case in order to be able to obtain court approval of your bankruptcy case. But let's assume that your case has gone along, it's been approved by the bankruptcy court in a Chapter 13 case. It has been confirmed, to use the legal terminology. And let's assume, for example, in a Chapter 7 case, the first hearing has already been held. What's the next step? How do you get that discharge? The next step really is that you must do, and this is really critical, you must do what's known as a personal financial management course. And it's also known commonly, a lot of times, I'll just call it the pre-discharge filing certificate. And it's so critical that, in fact, if you do not do that class, or if you do it and the certificate is not filed with the court, you will not obtain a discharge of your debts. And I've seen it happen before where the client has paid the filing fees in a Chapter 7 and got all the steps, gone to the hearing. There have been no objections in the case, but one step was missed. The most critical one is the pre-discharge certificate. And so it's absolutely critical that you do that pre-discharge certificate. In a Chapter 7 case, well, let me back up and talk about it in a Chapter 13 case. In a Chapter 13 case, you're going to do the pre-discharge class years after the bankruptcy case is filed. And that's simply because the Chapter 13 bankruptcy case lasts for 3 to 5 years typically. But in a Chapter 7 case, you're probably going to want to do that pre-discharge class about a week or two after your hearing, or after the case actually is filed. What happens in both a Chapter 7 case and a Chapter 13 case? Well, assuming that you've met all the requirements for a Chapter 7 discharge, all of the legal requirements, and assuming you've attended your hearing, you've done your pre-filing class, you've done your pre-discharge certificate class, the next step really is you're in a waiting line. And typically what happens is about 4 months after your hearing, you'll get a piece of paper in the mail from the bankruptcy court saying that all the debts are discharged. Now, from the time that you filed all the case until the time that you get that piece of paper, you're still protected during that time. So you don't have to have this order of discharge from the bankruptcy court to be protected. Again, you're protected by the automatic stay when that case is filed immediately. Now, in a Chapter 13 case, it's different. Again, because the Chapter 13 case lasts for 3 to 5 years, you wait until the tail end of the case to do this pre-discharge certificate. And so, your attorney's office will get a notice, and there's another additional form that has to be completed in order for you to get a Chapter 13 discharge. And in sum, those are the 5 or 6 steps to the bankruptcy process. If you have any questions, again, my name is Roger Guy. I hope that you found this video to be informative. If you haven't, you can always post a comment on how it may be improved or something of that nature. Again, thank you for your time, and I hope you enjoyed viewing the video. Thank you.